Hi, everyone. Welcome to part 3 of our webinar series, Legalease with the Ladies. My name is Sean Whalen. I am the co-founder and CEO of HopSkip. For those of you who are not familiar with HopSkip, HopSkip is a tool for planners to source room blocks and meeting space at hotel properties. And since our platform provides the ability for planners and hotels to facilitate the RFP proposal and contracting process, we knew it was important to understand the impacts from COVID-19 from both the planner and hotelier perspective. So in addition to many conversations within the planner and hotel community, we've been working with today's presenters on some new features that are focused on helping the planner think about the right contract language to include in their RFPs. And we wanted to make sure we continue to share those learnings to the rest of the meetings community. So that's why we brought you today's session, led by Barbara Dunn, who represents group clients, and Lisa Sommer Devlin, who represents hotel clients, to incorporate both of those perspectives in today's conversation. As far as today's agenda goes, Lisa, if you don't mind flipping to the next slide. We have a lot of content to cover in today's session, so Q&A will be time permitting, but we encourage you to please submit questions at any time during the presentation using the Q&A button shown on the slide, because if we don't have time for Q&A at the end of this session, those questions will help form topics for future webinars. And before we begin, Lisa, if you don't mind coming to the next slide, I just want to emphasize that one of the main reasons why these webinars have received such positive feedback is really from your input. Your input and feedback really does help shape the content that we present. And on that topic of feedback, we have 2 poll questions for you to kick off the session that we would love to get your input on. So please feel free to provide your response to the questions currently shown on the screen. And we'll get started. All right, great. With that said, I'll hand it over to Barbara and Lisa to kick it off.
Thanks, Sean. Good morning, everybody. Well, I'm going to give you another second or 2 to do the polling before we flip to the next slide. I guess people are still jumping in there, so let's give it another second. Okay. There's the results of our poll. So we're going to move on with that before we start here. Barbara, why don't you introduce yourself with a little bit more before we get started?
Good. Thanks, everyone. Good day. It's nice to be with you again. Thanks to our good friends at HopSkip for hosting another webinar, and of course my dear friend Lisa Sommer Devlin for tagging along on this endeavor. I know you'll find the information useful from both perspectives, and just first and foremost like to say that I hope you all are safe and well. I appreciate all the shout outs that are coming into us from all over the country, and certainly that's first and foremost. My background is representing groups in negotiating contracts for meetings, conventions, and trade shows, and been doing that for 28 years now or so. Needless to say, the unprecedented times that we live in have caused a lot of discussion and shift, and always happy to work with clients and partnering to find solutions to the challenging times that we live in. And I'm fortunate to get to work with and get to know my counterpart, Lisa Sommer Devlin.
Hi, everybody. I'm Lisa Sommer Devlin. Like Barbara, I've been representing hotels in group and convention related matters for about 30 years now. And not only are Barbara and I colleagues that work together frequently, often on the opposite side of positions, but Barbara and I are very, very good personal friends as well. So it's really fun for us to do this kind of webinar together. We love to present together and have been doing it for a number of years. And we think it's kind of helpful to everybody to have both the hotel perspective and the group and association perspective. And as Sean said, we welcome your questions, even if we don't get to them today. Maybe we'll get to them in another webinar in the future, because we hope to continue this process. So while we've talked a lot about COVID-19 in our previous webinars, we wanted to kind of shift the focus a little bit today and talk about some basic things that you need to think about as contracting is starting again. Because whether or not people believe it, this contractings are going to go forward. Let me back up. I'm sorry, somebody just walked in the door. That always happens when you do these things. We need to give a disclaimer that today's presentation is not legal advice. Well, Barbara and I are both lawyers, obviously. We can't give you legal advice about anything directly because A, you're not a client, B, we don't have all the information that we would need to give you legal advice. And so these are just general guidelines and things that we want you to consider when you're confronted with legal issues. Barbara, you want to add to that?
Yeah, I'll just say that, Lisa, you know, as Lisa mentioned, certainly our guidance today will be best practices. And both of us, Lisa and myself, come from the trenches, working with clients to work around a variety of issues. So we'll certainly offer up those best practices, but always engage your own legal eagle to make sure that that's something that will work for your organization.
So as I started to say before, contracting will return. Certainly customers are very reluctant to book events at this point, but it's starting to happen. And I'm hearing from my clients that customers are coming back to the table and are booking events. Certainly events are going to look different, and at least for the next few months or year, maybe we're going to have events look different, but we do need to get back to contracting. Barbara, what are you seeing from your clients?
Yeah, Lisa, I'm definitely seeing a need to get back to contracting, and I agree with you. That's a good thing. I also agree. I knew just as I would start speaking, the dogs would interrupt things. So
Barbara's turn is my dogs.
Yes, exactly. So Lisa, yeah, definitely seeing getting back to contracting, but meetings will likely look a lot different. So to me, the name of the game in contracts, and I know we'll dig in on specific items, is flexibility. Flexibility on all sides, not knowing what the bob and weave maneuvers are going to be.
And I agree, and keep in mind that everybody's taking risks going forward, and you have to look at what you're asking your business partner to do, how much risk you're asking them to take when you're doing these different kinds of meetings and events. But really what we want to focus on today is not something specific to COVID-19. We want to talk about things that we see all the time. Things that we see with industry veterans that have been doing this kind of thing for many, many years that continue to make similar mistakes, and we want to help you get past those mistakes so that you can focus on the things that are important about your events. And here's the number one mistake, huge pet peeve of mine: handwritten changes on a signed contract. There's just no reason for that to happen. What happens is you get these handwritten changes, and if it's me, you can't read what it says because my handwriting's terrible. If somebody's writing something in the margin, it's usually incomplete and not even a whole sentence. And you can't tell if it's been countersigned or initialed. And handwritten changes are the most common source of disputes in contracts. Barbara, what do you see?
Absolutely, Lisa. That's my number one pet peeve as well. Over the years, certainly you've seen a variety of disputes arise by the fact that the parties had made handwritten changes to the contract at the time of the meeting. Those people are long gone. Nobody can read their handwriting. And in a lot of cases, Lisa, it's technically not a contract because someone made a counteroffer on the written paper, and that counteroffer wasn't countersigned, therefore accepted. So we don't have a contract. So just even Contracts 101, it leaves both the group and the hotels exposed, and it's just another way that we see problems arise.
Yeah, and I mentioned December 31 on this slide because, as we all know, especially from my hotel colleagues, they're trying to get contracts signed at the end of the year to meet their goals, and we all understand that. But whenever I see a contract that is covered with handwritten changes, I usually guess it's signed at the end of the quarter or the end of the year. And I'm sorry, there's no excuse for that. You know, it's 2020. You can email things. You can always take 5 minutes to retype a contract. And usually when you do that, you're going to look at that handwritten change and you're going to stop and think and say, well, what exactly does that handwritten change mean? And we need to talk about this a little bit more. So take the time, do it right. It's always appropriate to do that. Another thing to do is a lot of times I see parties on both sides sending back and forth a PDF so that their business partner, if they want to make a change or request an edit, they have to do it in handwriting. And that's really not reasonable. I mean, the industry standard here is to send documents back and forth in Word so that you can use track changes and see what the edits are that people want and do comparisons of documents. Isn't that the way you do it, Barbara?
Absolutely. I mean, even just from the group side, it's a efficiency on cost. It takes me a lot less to put in a proposed edit than it does for me to explain on the third line after the word X, insert Y. So again, definitely some method. And the thing is, obviously, the tools and tracking them back and forth is that we're getting closer to the final work product, which both parties want.
Absolutely. Another thing that happens, and I just had this happen to me last week, is not properly naming the parties. The first thing you need to do when you're entering into any contract is find out the correct legal name of the party that you're going to be having a contract with. From the hotel side, I see things like, you know, Smith Family Reunion, which is not a legal entity and not somebody that you can sue. You need to find out who is the party I want to sue if they don't do what they're supposed to do under this contract. Barbara, what do you see from your end?
Yeah, absolutely. And I think, Lisa, one of the frequently asked questions that comes up is, you know, and especially nowadays with the hotel ownership changing hands, is the new owner bound by the contract? There's always that discussion that what if that changes, which in many cases it may likely. But in most contracts, the new owner, in most transactions, they would acquire both the liabilities as well as the assets, and contracts are really both. Has that been your experience as well, Lisa?
Well, most of the time that's true. If the ownership changes, the contracts that they have on the books are one of the assets of the hotel that would be transferred with that change of ownership. But as Barbara has pointed out to me in the past, she had a situation where a hotel was sold and they turned it into a Target. It wasn't even going to be a hotel again. So it does happen. And in that case, obviously it's a breach, and the now Target would owe money to the people that are no longer able to have their event. But again, you have to have the correct legal names of the parties. You also need to figure out who's responsible. Is it the third party meeting planner, or is it the customer that's going to be responsible under this contract? If it's ultimately the customer that's paying the bills and the customer that you want to sue, then the planner should be signing it as agent for the customer. But if it's an incentive meeting, perhaps where the customer hires the third-party incentive company to put together the entire event, and maybe it is the incentive company that's the responsible party. It could be either, but you need to figure that out. How do you approach those things, Barbara?
Absolutely. I think it's important on both sides that you ask who has authority to sign the contract, and that you find that out early on. And yes, I agree that if you're a planner, you're authorized on behalf of your client to enter into a contract in their name, that it's clear that you're denoted as authorized agent. Most hotels will also require a letter from the client or some other form to indicate that. And then for turnkey special events, incentives, as you mentioned, Lisa, definitely making clear that, you know, the contracting party is the third party. Sometimes there's a listing for the benefit of the group name, and that's pretty common, but it's a big deal. And certainly what you don't want to have happen is to get to the last minute and be in a used car dealership where they say, oh, wait, I got to go talk to my manager about signing the contract. And, you know, I say that jokingly, both on the group side as well as the hotel side.
Right, and there is no embarrassment in asking the other party, I need a letter saying that you are the authorized signer. If they're authorized to sign, then they shouldn't be embarrassed to get that authority from whoever is the head of their company or whatever. Another thing to think about is if it's an association, and Barbara can speak to this more than me, sometimes you need more than one person to sign. Sometimes you need board approval, right, Barbara?
You do, and again, I always encourage my clients to let their counterparts on the hotels know that up front, and talk about timing expectations. I think that's important. I was really encouraged, Lisa, the other day when someone brought up the signing the contract before December 31st. I thought, oh my gosh, how cool would that be if this December 31st we'd be as busy as we normally are? That would be a good sign. But timeline is important, and I think it's important as well to ask up front, what's your process, who will be signing, and what the timeline looks like.
Absolutely. Barbara, why don't you jump in and talk about using undefined terms?
Yeah, so, contracts often are fraught with terms which most parties think they understand, and yet when it comes down to dispute, we find out very unpleasantly that those are not defined. So it's important to go through all the terms in the contract and make sure that you understand that. Things like rack rate, Lisa, obviously that had been a common term. There's also certainly terms again, that are often used, contracted block, and yet it might be defined on page 1 as something different. So inconsistent use of terminology, and then use of terminology which you understand. Even the term picked up might be another situation. I mean, if we're talking about this in a dating context, it's probably a little different, as opposed to rooms utilized and paid for. So it's just tightening up the wording. But Lisa, you know as well as I do that these are the types of situations that really do come back to the group. And the point being, well, when we negotiated a contract, we understood what it meant. Well, that's all well and good, but when it comes time for the contract, that's certainly going to be interpreted differently. So you can't rely on that. And I will tell you, I think the current circumstances have shown a light, both on the hotel side and on the group side, of situations which should have never happened, clauses that were used, and now all of a sudden, normally no spotlight would ever be shown on it, but for the need to cancel or adjust the contract.
And the thing you need to keep in mind is that everything that you discuss and talk about leading up to the contract goes away once the contract is signed. You are bound by what they call in the law the 4 corners of your contract, whatever is in that document. So anything you talked about leading up to it no longer matters. If it's not in the written contract, it's not there, and you can't enforce it. So don't think, well, we all understood what that meant, because that's not going to be good enough. You have to assume that a judge who knows nothing about your industry, or people who have taken over your position after you've won the lottery and retired to Bora Bora, you have to, now it's my dog barking, I think. You have to assume that somebody else who knows nothing about this is going to have to enforce the contract, and they're only going to do that based upon that written document. Don't use undefined abbreviations. I see all the time, $100 plus. Well, I think that means plus tax and gratuity. Somebody else might think it means something else. I've had cases where a judge says, I don't know what plus means, and so the hotel doesn't get it. So you've got to be very cautious. Don't use those abbreviations. Again, look at terms like net rate. Net rate to me means rate less commission. I had a customer say, no, net rate means rate less expenses. In other words, your profit. You need to define those things. So anytime you see a term, you need to think about what that means. Barbara, why don't you start about addenda, our least favorite term. Well, you're on mute. Barbara, you're on mute.
All right.
There you go.
We can complete 1 box in the Zoom bingo. Well, 2 actually. We have a dog barking and the failure to turn off mute. So, this has been a pet peeve for both Lisa and I for a long time, but it's even been more prevalent now when a client will call me and say, oh, we negotiated an addendum, we're going to change the dates of the meeting. And I'd say, well, you're really going to amend the contract, not an addendum, because an addendum is something that comes along with a contract. It's something that provides additional information. So for example, if you say, the group will have the function space set forth and, the addendum that will detail, let's say, the function space schedule or agenda, what comes after a contract signed should be called an amendment. And so when you are changing contracts right now, if you're amending the dates or whatever the case may be, make sure you're using the proper terminology. And remember, it takes 2 parties to amend the contract. It takes 2 parties to change it. And I think my additional add-on here, Lisa, is that groups and hotels have been working together very well over the last several months to pivot meetings, change dates, etc. And in doing so, a lot of times it's, okay, well, we'll waive cancellation fees, or we'll post your deposit toward this other meeting, whatever the commitment had been made. And yet, that doesn't make its way in the amendment. So now we're going back to this 4 corners concept of a commitment that was made maybe in a phone call or an email, but hasn't been firmed up. So the amendment is your tool, your vehicle for doing that. And I think it's important that groups consider doing that, obviously for the hotels as well, to make sure that everyone understands what's coming along, if you will, with the change to the contract.
Sure. And let me pivot back a little bit to using addendas to negotiate at the beginning of the contract. So often, Barbara and I see a hotel contract, and then stuck on the back is the customer's addendum. And as Barbara says, addendum is not really the right word for that. That's not negotiating, that's lazy contracting. Instead of negotiating a cancellation clause that you both are happy with and agree on, you have a cancellation clause in the hotel contract and a cancellation clause in the customer's addendum. And the customer always says, well, that addendum will control. It doesn't always necessarily. So it creates more problems than it's worth. Negotiate one complete contract with clauses that both parties like, rather than having essentially two contracts that are stuck together. As part of that, when you're negotiating, if you're a planner and you have a specific clause or specific term that you really need, that's something that you should be bringing out at the beginning of the negotiations, not at the end. So many times I see the negotiations get all the way to the contracting stage, and then the customer says, oh, by the way, here's my addendum. HopSkip does have in its software a way that you as a planner can put in those key clauses that are, something that really matters to you. That's something that the software allows you to do, so you can get that in front of the hotel partner at the very beginning of your discussion, which is when you should be doing that, not at the end. Have one final signed integrated contract. And again, this goes back to what Barbara was saying, amendments versus addenda. An addenda clarifies but does not change an existing contract. So you have a contract to sell 100 bicycles. After you sign the contract, you forget, oh, we didn't talk about what color they are. An addenda would be used to say 25 are blue, 50 are green, 25 are red. It doesn't change anything. It just clarifies what's already there. An amendment changes what's already contracting. So you change from 100 bicycles to now it's 150. That's what Barbara's talking about, that everybody's doing now in moving meetings, updating meetings, whatever it is that they're doing. That's an amendment, not an addenda. Neither one of those really belongs at the time you sign an initial contract. You should have one complete integrated agreement. If you change it later, you're doing an amendment. If you have to clarify something like Barbara said, if you need to put an addenda on that specifically lists the space but doesn't change the commitment, that's an addenda. Amending an amendment, you can do that, but that's something Barbara and I talked about a lot recently. Sometimes you have a contract for an event, let's say it was going to be in May of 2020. You did an amendment to move it to October of 2020, and now you're deciding you're still not ready to go in 2020. And you're going to move it to 21. Do you do a whole new contract, or do you do another amendment? You can do another amendment, but sometimes it's easier to do another contract. What do you think, Barbara? What are you doing these days?
Yeah, exactly, Lisa. That's the criteria that we're using. If it's a simple date change across the contract, typically that can be done by an amendment. But if we're changing other terms, maybe concessions, function space, etc., might make sense to just sign a new clean contract. Multiple amendments lead to a patchwork quilt, and lots of folks rely on the fact that the amendment will say that if there's an inconsistency between the amendment and the contract, the amendment will control, and think that that will take care of anything that might be inconsistent that wasn't mentioned in the amendment. So it's really important. That's not a cure-all. If you're going through that contract, you need to look at that. And I know Lisa, on the next slide, really focusing on, syncing up all of the changes that are made in the amendment, syncing it up in terms of what was in the contract. So for example, if you've agreed to reduce the room block, but the room attrition fee provision in the contract is based on the original block, that change needs to be translated in the attrition fee provision. Similarly with cancellation, that needs to change as well. And so what we find is a lot of time one component of the change is translated into the amendment, and yet there are other components that aren't, which leaves the group and my side exposed to the potential that will be construed against them. Maybe the block not being adjusted is going to hurt them when it comes to attrition, or if they were to cancel. So it's really important to sync up those changes. So it's not just simply changing the date on page 1. It's really going through and integrating every change. And I've done a few of these, Lisa, when, again, I get down to sort of the list and I kind of pause and say to the client, you know, we may be better off just, you know, issuing a new contract. And again, I believe, Lisa, that benefits both parties. Again, our goal always is to have that one clean contract.
And I agree. And again, every circumstance is different, so there's no hard and fast rule about this. But you know, in moving these things forward, you got to think about not only are we changing the dollar number in the performance or the cancellation, but we got to look at the dates, because I've seen a lot of these meetings that have been moved, that it was moved from, you know, May to October, as I said, and they didn't adjust the dates in the cancellation clause. And so now it's saying, well, if you cancel anytime after April 1, you owe, you know, this huge amount that should have been moved as the date of the event was moved. So you've really got to go through and look at all of those things. And again, that, as Barbara and I say, sometimes it's easier to just do a new contract and get all those things taken care of than to try and amend and amend and amend and amend. You know, it's a case-by-case thing. Barbara, you want to talk about corporate planners and standard purchasing forms?
Yes, Lisa. So, you know, a lot of the corporate planners listening today or have worked in corporate planning capacity are used to, you know, procurement, used to terms and conditions that they might use for all vendors. And yet we know when it comes to hotel contracts, for example, a lot of those widget type clauses don't apply. And so it really is a matter of one size doesn't fit all. And, you know, I've encouraged planners over the years working in the corporate setting to really interface with procurement to make sure that those terms can be customized in a hotel context, not just the general ones that are issued. And here again, Lisa, where we find, especially a corporate legal side, is having these addendum of terms that need to be in the contract. And of course, those are terms that you would put in at the outset, as we talked about earlier, and certainly RFPs through the HopSkip platform would allow that as well, putting it on the table. But it is important to make sure that what you're giving the hotel from a corporate standpoint are really the key terms that are specific to your event. You know, they're not specific to production at a factory of a particular good or shipping. A lot of terms in there on shipping. A lot of this is not applicable. So one of the things as well, I know Lisa and I have been working on in conjunction with HopSkip, is just giving some explanation around some of these basic clauses within the platform, using their contract wizard tool, so you can see that. And, you know, my disclaimer here is obviously, again, you want to talk with your legal eagle, but it is important to identify what clauses are important to you aside from the procurement. But in an ideal world, getting your procurement to go along with having terms that are specific to events and hotels as opposed to manufacturing.
Yeah, and that's true. That's a battle that my hotel clients have with procurement all the time, because if you get a procurement person, they think that, you know, buying hotel rooms is the same as buying pencils, and it's not. And sometimes you have to get past that procurement person so that you can get to the terms that you really need. So those are out there. Another thing that we often hear is, if we change this clause, we'll have to get legal involved. Well, legal review is not a bad thing. I know everybody talks about bringing in the lawyers as if it's a terrible thing, but the lawyers are there to protect you and to help you and to make sure that what you think your contract is saying really says that. An ounce of prevention is really worth a pound of cure. So many times, Barbara and I get involved in disputes where if somebody would have just taken 5 minutes to have somebody run over a clause with their lawyer, it wouldn't have happened. And if you're the planner, do you want to be the one that's making that $100,000 or $1 million mistake? What do you think, Barbara?
Absolutely. When a client says, well, you know, they said they're going to have to get their legal involved, I said, great, I can talk to someone about this and we can work it out, because Lisa, you know, the lawyer's job isn't always to run interference, it's to help broker an arrangement. We want the clients, our customers, our clients to succeed. So that's a good thing. So, you know, to me, that's an old school salesmanship. Maybe that should be, you know, not put out to pasture in days like these. But the point, Lisa, you made about contract language and taking time to review with legal eagle, you know, I always say it's easier to keep you, and cheaper to keep you out of trouble than to get you out of trouble. I mean, even a word, Lisa, as simple as per night or nightly in the context of a room block attrition clause makes a huge difference in liability, because rather than attrition being based on a cumulative use of the block, it's per night. And that's a huge financial error, and none of you want to be on the receiving end of this. And I know, again, the light has been shown on contracts in a way that like no other with what's been going on in the past months. You know, why did you have this lousy force majeure clause? Or why, you know, there's been a lot of that finger pointing. Again, at the end of the day, we want to solve it. So, you know, my strategy has always been work with your legal eagle to get clauses that you can use on a regular basis, and that you understand enough to know which components could be changed, what other suggestions you might have, you know, have those fallback provisions, because I think that allows you to work very nimbly. And, you know, then you're not necessarily always looping in counsel as you need to. It really streamlines the process. Lisa?
And, you know, a lot of people think that getting legal involved is going to be time consuming and expensive. And that's not necessarily true. Yesterday, I had a hotel, excuse me, a hotel come to me and say, oh, this is the clause that my customer's legal says that we have to have. And their legal is Barbara Dunn. And I said, really? And I you know, emailed Barbara, and 5 minutes later, it's like, okay, now we're done. You know, so it doesn't always take a lot. Sometimes you just need to get that connection between the two legals, and they can solve something that parties have been fighting over for a long time. So don't think of it as necessarily time and money, but if there is, it's time and money well spent. Another issue that we see a lot in contracts is customers assuming that anything that is good for the hotel is good for the customer. And that's not really true. The hotel and the customer are not in the same position. They have different goals, they have different responsibilities, they have different damages that they suffer if something goes wrong. Barbara and I strongly agree that mutual cancellation clauses in a contract are a bad idea. The damages that the customer suffers if the hotel cancels the customer are completely different than the damages that the hotel suffers if the customers cancel it. So having a mutual clause makes no sense. The cancellation clause is supposed to be a reasonable estimate of the loss, and they are not if they are mutual, because they're not estimating the same thing. And if you have a bad clause like this, it could be thrown out, and then you're going to have to prove actual damages, and it's a real mess. Barbara, you want to jump in here?
Absolutely. Just to echo that and say that, yes, I agree. Mutual cancellation fees are not a good idea. And, you know, for the groups listening out there, you don't have to have a cancellation by hotel clause in your contract. If the hotel were to cancel on the group, aside from force majeure, the group would be entitled to get damages, which are really all the direct costs to move the meeting, find a new location, difference in room rates, etc. It is helpful to include language on cancellation by hotel, however, so you could expand the footprint a little bit, maybe get recovery for attorney's fees. But what I see sometimes, Lisa, when groups are doing that, and this is understandable, the hotels will want to put a cap at the end of that sort of grocery list or laundry list of what the hotel would be responsible for paying for. You know, I had one yesterday, it was, you know, no more than $30,000, and just said to the client, I can't tell you whether this amount will be enough for you or not, you know, because of when the cancellation occurs, where it occurs, when can we find, you know, locations, etc. So to me, that's a similar challenge as it would be for a mutual cancellation fee to kind of determine an amount which would reflect reasonable damages.
And I don't really disagree. I know a lot of my customers or a lot of my clients like those caps. It makes them feel a little bit more secure. But I can certainly understand your reasoning why that's a question. One thing to think about is that a lot of times customers put in their contracts that the hotel will not cancel the group. That's not going to be legally enforceable. It gives you a false sense of security. If a hotel decides they're going to cancel you, they can cancel you. And it's not about you, it's just business. And so that doesn't really help you. It's better to know that you're going to get paid for having to move your event. And many a time, and maybe I'm getting ahead of myself on the slide, and I'm sorry if I am, many times it works really well for both sides. Instead of waiting to put together that whole laundry list of what your additional expenses are, is to just agree on an amount. The hotel comes to you, says, look, we got to cancel you, we'll give you $50,000 and go find a new place. And usually that works very well, right, Barbara?
It does. And at that time, then the group has a better idea of what those costs might be. Again, we would know the timing of when that occurred, where they could go, et cetera. Lisa, you may recall several years ago on the point you were just making about the hotel not canceling for the sole purpose of booking another group. I think the language we had was the group not moving its meeting, for the sole purpose of canceling for the sole purpose of moving its meeting. And, we both agreed that, at the end of the day, that what the hotel would want to recover from the group would be liquidated damages. So putting that in there, first of all, it isn't going to make it happen. And second of all, certainly I know the hotel wouldn't want that to be construed as that means damages are different, that the clause isn't enforceable. So I know sometimes when I take that language out of the contracts, a lot of the groups say, why would you do that? Why would you take out that language about hotel won't cancel for the sole purpose of booking in the group? And I say to them, first of all, it's like a no walk clause, right? Not going to make it not happen. It can happen. And you would rather understand what the liability is if that were to happen, as opposed to kind of being, hung out in the middle of nowhere. So if you see that change coming across, that's really why we just want to make sure the parties are clear on when cancellation fees are owed and when they're not.
Yeah, absolutely. Oops, I'm going the wrong way here. Cancellation, let's see, I did get ahead of myself. So saying the hotel will not cancel will not help. And I want to focus on it's not personal, it's business, because it seems like every time a hotel has to cancel a group, the group comes and says, well, we're a great customer. How could you do this to me? How could you, this is terrible. Again, it's not business. It's just business. I mean, if you've got a $50,000 meeting and the hotel has an opportunity to book $1 million meeting, that's going to happen. It's just the way it's going to be. And that's the hotel's obligation, the management's obligation to their owner to do that. It's not a personal thing. And instead of getting upset, start talking about what money you're going to get for having that inconvenience. Right, Barbara?
Absolutely. I mean, once we kind of bring client in off the ledge in those situations, what are we going to ask for? This is the brass ring. Double booking a function space. How can I help you with your problem? Figure out what it is going to take. And we both been on the end of those and trying to negotiate. But understandably up front, this is not a pretty exercise. And one thing I could see happening, Lisa, which would be a good thing in some ways, it's strange to say this, but as things go on, if nonprofit groups have booked ahead future years with meetings, and then the corporate market starts picking back up and wants to book meetings, there may be a lot more circumstance where a nonprofit group might get bumped at a hotel for purposes of a corporate group. So even though right now we don't anticipate, I had a hotel say, well, we would never cancel on the group, but we don't want to put the clause in the contract, like, come on. So, from that standpoint, it's still important to include this language, I think, regardless of the circumstance. But more so than that, it's just really understanding how it would work if that happens. And, you often say, Lisa, you've never litigated, I think, on a case involving the hotel canceling, and I've never been on the side of that too. Sometimes it takes more arm wrestling, but ultimately the group gets what it needs, and the hotel is able to transition out of that contract.
Yeah, let me add and clarify what Barbara said. In the 30 years I've been representing hotels, I have no idea how many times a hotel has canceled a group that I've been involved with. But in all that time, I've only actually had a trial or arbitration one time when the hotel was unable to reach agreement with the customer that it had to cancel. Every other time that a hotel that I've represented has canceled a group, we've been able to come to agreement on what the hotel is going to pay. So if that gives you any confidence or any solace, I hope that it does, to know that that when hotels do have to cancel a group for whatever reason, they do understand their obligation and they come to the table and they do what's right.
Yeah, and they often come to with a solution, right? You don't pick up the phone and call them a problem unless you have your solution. So that's always helpful to the group as well. They may not hear it at the time, but it's helpful.
Right. So we could do a whole session just on liquidated damages, but just a few things that we want to highlight for all of you is that liquidated damages are supposed to be a reasonable estimate of the loss. So when the hotel is asking you to pay for cancellation or performance or attrition, whatever you want to call it, it's supposed to be an estimate of what they're going to lose if you don't completely comply with your contract. It does not have to have the word profit in it. As long as the amount is reasonable, it doesn't have to say that. As a matter of law, it does not have to give resale for credit. The reason that hotels have that sliding scale of damages that increases as it gets closer to the event date is they're estimating their ability to resale. So you don't have to have that. But if you do agree on a resale, you have to have a very specific clause outlining how that credit will be. So you're supposed to reflect both the potential of profit and the potential of resale. Barbara, can you talk about how you approach these clauses?
Yeah, absolutely, Lisa. So I try to guide clients away from the use of the term profit, because at the end of the day, I think it just raises more ire on the other side. You know, how do you know what my profit is, right? So at the end of the day, I think it's important to, I personally like to just have a dollar amount plugged in, because I think that's helpful. And here again, earlier we mentioned that concept of net rate, net of what? Right? So there's a lot of issues that come up as we're backing out commission, are we backing out a rebate, whatever the case may be. Also, I see a lot of average group rate. So if you're a group that might have 4 tiers of rates, and maybe your majority is on one side, but you've got some high rates for suites, that's going to weigh it down. So here again, I definitely recommend plugging in the rate when you can and just avoiding the debate altogether. The same is true, of course, Lisa, as it relates to the date side of the columns on the liquidated damage clause. You and I have seen more than once cancellation fee parameters that drop off a certain period of time. You know, August 21st, 2020 until December 31st, 2020. March 1st, 2021, right? And what happens in that interim? And that is an issue. So, and one thing I also want to point out, and again, commend the hospitality industry collectively as a whole, with all of these bob and weave maneuvers that we've had to make, appreciate the fact that the hotels have always been willing to discuss. If a group has to make a decision about a go, no go in its meeting, appreciate the fact that the hotels are often receptive to looking at amending the contract, and specifically amending the cancellation fee provision to allow a certain tier of damages to go for a longer period of time. So if it ends on August 31, 2020, they'll agree to extend it maybe 2 more months at that fee in order to give the group more time to make a decision. And again, I appreciate the fact that the hotels have been willing to engage in those discussions, because it's helpful, obviously, from the group side as the groups go through their own process of determining whether they could go forward with the meeting.
Right, absolutely. Let me focus again on a couple of things that Barbara said. We both agree that we'd rather just have a dollar amount. And so instead of average rate, just put down, you know, $200, whatever it is, so that you know what you're agreeing to. Have a dollar amount in your cancellation clause. I don't like it when it says 75% of, you know, revenue or whatever it is. Put in whatever that number is so that everybody knows. And then put January 1 to March 31. Don't do, you know, 60 days to 200 days. I was leaning over to get, I've got this little thing that it's a little date thing that I have to use that calculates how many days out. And I'm sitting here thinking, okay, if the lawyer is sitting here having to calculate how many days is 180 days before December 31st or whatever it is, that's too complicated. Just put in dates and be very cautious and make sure that you've got them right. As Barbara said, if it goes from March 1 to June 1, then the next tier should start June 2 and go to whatever it is. Don't have gaps. I see gaps all the time. And those are simple mistakes that can cost a lot of money if you don't do it right.
Great.
No attrition clauses. Important. I hear customers say all the time, I won't sign a contract with an attrition clause in it. And I say, good for you, because now you are now committed to 100% of the block. Right, Barbara?
Yes, and Lisa, you know, as a result of your position on this issue, clients of mine listening or groups, my recommendation, of course, as yours has always been, that you can't just rely on silence, that you need to specifically say no attrition. But even one more, to explain that that's a business consideration between the parties and won't be used as a way to invalidate the contract. Because of course, contracts are, in order to be a contract, it's required that there be consideration or skin in the game. And the thought is that if there's no issue with attrition, that must mean that there's no skin in the game. That means you don't have a contract. That means we don't owe you damages if we cancel on you. So avoiding that gotcha is really important. And many of you have heard me say over the years that to me, the better thing than a no attrition is to build an attrition clause, which will never come into effect, because it allows for a lot of slippage. It allows for a good multiplier, as we talked about, a dollar amount that's favorable. It specifically talks about credit for resold rooms, et cetera. So to me, that's often a better approach. But now on the street, you know, many hotel chains are offering no attrition. And you know, that understandably, in light of what it means to go forward, but I caution, you know, looking at those to you, make sure you're not just leaving it to silence. Lisa, obviously, this is going to date us a little bit, but the women's bowler case involving the Hyatt Buffalo going that long time certainly established that. And if you don't have an attrition clause, you're responsible for what? 100% block, right?
Right. Well, or if you affirmatively say no attrition, the problem with enforcing that contract is here you have a clause that says if you cancel, you owe $100,000, but if only one person shows up, you owe nothing because there's no attrition commitment. A judge is not going to enforce that. They're going to say that doesn't make sense. That's crazy. So affirmatively saying no attrition opens you up to the contract, as Barbara said, not being enforceable. On the other hand, in today's world, you're not going to be able to do this forever, but in today's world, hotels are going to be much more flexible. You know, whereas before, when Barbara wants an attrition clause that says we only have to fill half our block, you know, hotels would probably push back on that. You might be able to get that now. Hotels now are in the position of some business is better than no business. We're all in an uncertain time. We don't know how things are going to go forward. We don't know what's going to happen. And hotels are going to be willing to work with you to say, let's do what we can. Let's try and get the business back on its feet. Let's try and get our staffs back to work. Let's try and move forward. And so they're going to be flexible, but don't expect them to say, oh yes, we're going to have a no attrition commitment in 2023. But for, you know, the rest of 20 and the first part of 21, sure, there's going to be lots of flexibility out there.
Yeah, Lisa, and I think part of that flexibility, and you have this in the PowerPoint, is more review dates. So more opportunities for both the group and the hotel to review. And specifically those hotels which are offering no attrition, groups should be prepared that the hotel is going to want more review dates, which is understandable, making sure you're on pace with picking up your block. But again, you know, no attrition means basically saying, you know, group won't be held responsible for damages if it fails to utilize, you know, the contracted room block. Also remember too, some concessions are tied to pickup. So if concessions are tied, even though there might not be an attrition fee, you may be charged for concessions or risk concessions taken away and function space. Again, all of those things are tied to this. So just be careful of the deal that's being offered to you and make sure, you know, you've looked at parameters. And again, I agree, running it past your legal eagle for a quick review it will be a lifesaver. Lisa? And
just to add to that, what Barbara said, you know, talks about no-go dates. We're having lots of those discussions in this industry now. You know, at what point does a group have to either commit or not commit? And hotels understand that, but the flip side is true as well. At some point, the hotel has to know what's going to be happening, especially this past spring as things were starting to unravel. We had customers that were canceling literally on the day of arrival. By that point, the hotel already had all that food purchased and sitting there, and it had all of its staff that it was committed to pay for, and the hotel was much more damaged than if the customer had canceled 30 days out or 15 days out, depending on the circumstance. So again, the parties are going to have to start working together to make these no-go decisions as things are unfolding. And again, as we said, set a date for a final confirmed block. And one more thing on that no-go situation, I'm also hearing a lot of customers say, well, we have to make a decision now because we have to start hiring our vendors and we have to start ordering things. Understand that everybody that's involved in this industry is facing the same hurdles and everybody has to be flexible. So you can be building as a customer and building into your contracts with your vendors similar clauses that you're building into with your hotels, saying, you know, we have a right to adjust this if based on circumstances things change. You know, they want that business too, and they're going to be more flexible. Are you doing that, Barbara, with your customers' vendor contracts?
Oh, absolutely. I mean, that flexibility has to hit at every level on the going forward. And yes, I think that's a good strategy to have. And to your point, everybody is in the same boat. and the ability to maneuver around a lot of different obstacles, whether that be modifying the program, canceling the program, et cetera. Many vendors, not on the hotel side necessarily, but other vendors to our industry had come to us, they don't have force majeure, they don't think they're damaged, or they don't know what their damages are. There's been a lot of consternation, again, understandably so, but it speaks to the fact that, all those components of your meeting make up what ultimately may be your liability, again, both group side and supplier side. So it is important to really make sure that you have the flexibility. And remember this, I've had a lot of clients say, well, I want to renegotiate that contract. Remember, it's not called renegotiation, it's called begging. But most hotels, again, I'm sure groups as well, approached by the hotels, are willing to look at contracts that are in place and look for flexibility that might be needed. So I think it's appropriate to ask. You don't ask, you don't get. But I do think it's also appropriate that if you're asking for something, change in dates, reduction to block, et cetera, that you're willing to offer something in return. Maybe that means additional food and beverage expenditures, or maybe signing for another meeting. It's just, to me, it's the incentive to amend the contract that will ultimately benefit both parties. Lisa?
Absolutely. Absolutely. So let's move on to indemnification. Indemnification is something that's very misunderstood in the meeting industry, and it's really a pretty simple concept. It simply means if I get sued for something that you did, you're going to pay me back. And that's really it's all about. Indemnification includes payment for settlement, because 99.9% of all claims that are filed are ultimately settled outside of court. And I'm really not exaggerating, that's really the figure. Most cases are settled without ever going to court, so indemnification would pay for the settlement. If it did go to court, it would pay for the judgment, for the attorney's fees, the court costs, all those kinds of things. But what we see in the industry so often is that there is a mutual indemnification clause. And so it says hotel will indemnify group and group will indemnify hotel. So you have the event and Susie attendee trips and falls and sues. Typically she's going to figure out a reason to try and sue both the hotel and the group, because the more people you sue, the more money potentially you can recover. So what happens is if you have this lawsuit filed, group then says, oh, hey, I got sued, hotel, here, I'm tendering the defense to you. That's what it's called legally. I'm tendering it to you. You have to defend me. And the hotel says, well, gee, that's funny. I got sued too. I'm going to tender our case to you. You have to defend me. And so both sides end up defending their own case. It settles and nobody indemnifies each other. So I'm not a huge fan of mutual indemnification for that reason. I think ultimately it doesn't really help either side. And the reasons that hotels want groups to indemnify them is because if a group comes into the house and does something, the hotel is always going to get sued for that as the operator of the premises. So that's why hotels like indemnification in favor of the hotel, and why they're not really fans of mutual indemnification. It's become very common in the industry, but I think that's just because people don't really understand what it does and how it's going to work. Barbara, how do you approach it?
Yeah, I agree with you, Lisa. I mean, to me, indemnification is the most important risk management tool that groups have, and it doesn't cost you anything. It costs you the time and effort to negotiate in your contracts. Agree, in a hotel setting, there's a lot of shared risk, and the scenario that you gave is certainly one that may very well happen. And again, ultimately, it's going to depend on the facts and circumstances of the particular situation. With other vendor contracts, though, I remind my groups, when you're a passive consumer of goods or services, so bus transportation, for example, you shouldn't expect that indemnification is a two-way street. It should be a one-way street, meaning that the group is protected. And of course, Lisa, the other I word that Tisdale mentioned is insurance. Those are your two best risk management strategies. Although I say best, risk avoidance is the best. So, all the things that all of the folks listening in do on a daily basis to make sure meetings and events can happen safely are all things that we all want to do to avoid risk in the first place. But having fallback, indemnification, and insurance is a good strategy.
Absolutely. Yeah, and basically, if insurance supports your indemnification. Before I worked for hotels, I spent a lot of years as a insurance defense attorney. I was the attorney that was hired by the insurance company when their insured got sued for something. And I will tell you that $1 million liability case is very common. Happens all the time. 5, 10, $20 million cases that are settled depending on the nature of the injury. And so if whether you're a hotel or a customer and you get sued, you're not going to be able to write a check for that kind of liability, which is why you have that insurance coverage, because that's what it supports you. It pays for your costs of defense and it pays for the settlement. Why do hotels resist naming customers as additional insured? Because you have to think about the fact that hotels are having hundreds, if not thousands, of events in their house every year. If they went to their insurance company and asked for a certificate of insurance naming each one of those customers as an additional insured every time, it would be a full-time position for someone at the hotel, and their insurance premiums would go way up because of all of the additional insureds that they had. Hotels ask for the customer to name them as an additional insured because it's a one-time thing and it usually costs little or nothing. Barbara, you would like to talk about other types of insurance for your clients?
Yeah, just about event cancellation insurance. For those of you who had it in place prior to the pandemic and had to cancel a meeting, certainly evaluating coverage was important, whether communicable disease was covered or not. Going forward, COVID-19 won't be covered, and likely maybe no communicable disease would be covered. However, it's still good insurance. So I definitely recommend clients look at that. If your meeting makes money, you should look at insuring it.
Force majeure impossibility, we're not going to spend a lot of time on this because we're almost out of time anyway, but we just want to reiterate what we've talked to in the past. It's a very limited legal doctrine. Typically under the law, force majeure means no how, no way, you cannot go forward with what your contract is. You don't need a clause. The law applies whether or not you have a clause in your contract. But if you have a clause, that will control. Whatever you say in your clause controls over what the basic law is. The problem that we're having now throughout this industry is, when can you invoke force majeure? Barbara, what are you telling your clients right now?
It depends. It depends on the language of the contract. I think, Lisa, as you point out, illegal, impossible, commercially, or impracticable. Those are important terms. So to my standpoint, the stronger the clause is for the group, potentially the farther out they could cancel. But it's going to depend on the facts and circumstances. Where is the meeting? When is the meeting? Who's coming? What are they doing? All those sorts of factors. So it very much, there's definitely no general rule. And, Lisa, again, I think hotels have been flexible with this, but to what extent can they continue to do so? So groups are really going back and thinking about how they want to move on this and how they want to invoke the clause. And, the response, I know a lot of the hotel side have said, it's too early to invoke force majeure. In that sense, it really does depend on the contract language. So it shines a light on it. But Lisa, you and I agree that, the language that's been out there doesn't need radical changing, if at all, as long as you have these basic bread and butter items about, what that standard of impact is. So definitely, if you haven't looked at your force majeure clause, work with your legal eagle to do that. A lot of you found out, maybe the hard way, that, having a better clause would have given more options. But at the end of the day, many of you were negotiating in 10 years of a seller's market. It was difficult to necessarily get the terms that you needed. But Lisa, I think that's overall part of the strategy that both groups and hotels need to analyze going forward. And speaking of going forward, I hope that, I hope the 10 Chide continues to go forward in a way that will make everyone feel safe and comfortable. And again, just want to thank my hospitality industry friends on both sides of the aisle for everything that you're doing, and your ability to work together is certainly a hallmark of our industry. And Lisa, I'll turn it back over to you.
Okay, so I'm sure you all noticed that I just zipped through about 10 slides because Sean popped back in, and that means he's given us the hook. So, we could talk about this forever, and we will on another webinar at a date to be determined. We've got one more quick poll that we need to do. No, I don't know how to do that.
Greg's going to kick it off, and I'd like to give a special thank you to Barbara and Lisa again for a great webinar. Thank you to all of the registrants and today's attendees. HopSkip will be distributing the webinar link early next week, and Also, in addition to providing education through our webinars, Barbara and Lisa have partnered with HopSkip to implement this information into our platform as well. So if you have any interest in learning more about how HopSkip can help drive confidence in your sourcing process, please let us know by clicking yes, which is shown on your screen right now.
I finally figured out how to do it.
Good job.
Lastly, HopSkip is offering all webinar attendees today free pro access to the platform for your first RFP, and we would love the opportunity to show you HopSkip and hear any feedback you might have from today's session. So please feel free to contact us at info@myhopskip.com. Thank you all and have a wonderful weekend. Appreciate it. Take care.
Thanks, everybody. Bye-bye.